bring you information and analysis. My name is Dumila Matez. Remember, you can also be part of our discussion by tweeting us at Recourse or send us an email and say to us which are the issues you think we should cover on this show at rightsandrecourse@sabc.co.za. According to the Department of Transport's Road Safety Strategy document for 2011 and 2020, road fatalities are a major contributors to unnatural deaths. According to the document, every day 3,200 people are killed on our roads around the world, with South Africa contributing 40 deaths a day. Human behavior and the unwillingness to abide by the rules of the road, as well as inadequate enforcement, including the lack of follow-up on fines, which result in a culture of impunity in respect of punishment of the offenders. During a briefing update by the Minister of Transport, Mr. Dipuo Peters, and the agents responsible for road safety, the Road Traffic Management Corporation, they concluded that this situation calls for desperate measures in a desperate situation. To mitigate against those arrested for drunken driving, for instance, they propose that the Schedule 3 offence under which drunken driving is classified be upgraded to a Schedule 5 offence by our justice system. This, in the view of many, would have serious consequences for those arrested for drunken driving. In some cases, they could infringe on their constitutional rights. And today on Rights and Recourse, we explore this issue and attempt to find solutions to a very desperate situation. But first, let's take a look at this insert.
We are not against alcohol. We are not against people taking alcohol. We are against those who drink and then go into a vehicle and drive it. That is the person that we say should not be allowed to be on the roads of South Africa. We are working with the Department of Justice to get these people behind bars. We are working with the Department of Justice to get stiffer penalties. And that is why we say for speeding and drunken driving, we want Schedule 3 to be changed to Schedule 6. We cannot have traffic laws that are allowing for people to be killed on our roads. We say if you are murdering people on the roads, you must be held responsible for that murder. If you are a speedster, a drunken driver, you're a murderer. So you need to be held responsible for that.
To discuss today's topic, we are joined in the studio by Advocate Makosini Msibi, CEO of the Road Traffic Management Corporation, and Mr. Howard Dembowski, National Chairman of the Justice Project South Africa. Gentlemen, good afternoon and welcome to Rights and Recourse.
Good afternoon to me as well as the viewers of home.
And good afternoon.
Advocate Msibi, let's start with the Minister made reference there to Schedule 6, and many people have a bit of a confusion. I looked at those two schedules. I found them to be the same. Schedule 6 is just broader than 5.
Well, that was initially the issue that we look at both rescheduling, Schedule 5 and Schedule 6, but the discussions have come to the conclusion that Schedule 5 might be appropriate.
Another thing I wanted to find out is, are we talking here about a driver who gets into a vehicle under the influence of liquor without causing an accident and he gets arrested, and then that charge will then be scheduled under Schedule 5?
The two issues, on the issues that we're dealing with in terms of the rescheduling, it's at the time of the arrest, before appearing before a court of law. That's what we want to deal with first. The doing away in terms of the discretion as dictated to by Section 59 of the Criminal Procedure Act. That's one element. The second element, it's at the conviction stage that we're then talking of the harsher sentence. That's the basis of the rescheduling from our point of departure.
The first instance and the second instance, can you explain to me, it's if the driver is involved in a fatal accident, then he will be charged under Schedule 5 or 6.
We're proposing that reckless and negligent driving, as well as drunken driving, be reclassified under Schedule 5.
Irrespective of whether they are involved in an accident, a fatal accident.
That's not the issue. The issue is you arrested for reckless or negligent driving, or you're driving under the influence of liquor. We are then saying, let's then charge you in terms of Schedule 5. What does that mean? As I've alluded to, two issues. One, it's at an arrest stage, because you might be charged for reckless or negligent driving, or you are driving under the influence of liquor. Section 59 of the criminal procedure applies. The police in charge at the charge office can and has a discretion to give you a bail in terms of Section 59. We are saying, in order to deal with this matter, let's deal with the freedom first, that you be classified like any other person that has been charged of murder, robbery. And it doesn't mean when I'm charged I'm already guilty, because our law presumes you innocent until proven guilty. So we're dealing with the first element. The second element, it's at the conviction stage. We're then saying at the conviction stage, we are calling for a mandatory minimum sentence that you then serve not less than 2 years in prison. Currently, when I'm arrested for drunken driving, I'm given a fine at the conviction stage, or I do the admission of guilt when I appear before court. I'm giving 40,000 and perhaps a suspension of the driver's license. Is that a deterrent on its own, Ocha? Is it rehabilitating me? Because the sentencing has certain components in itself. You need to deter. It needs to have a deterrent effect. It also needs to rehabilitate the offender. Initially, we're sitting with a problem in this country where offenses arising from motor vehicles or traffic fines are not treated as serious as they are. They are just mundane, offenses, and everybody knows that I get arrested, I get a fine, I get a traffic offense, I'm served with Section 56 notice, and that's the end of the story. That should then come to an end.
Howard, I just want to get something right here. The advocate says when you are arrested for being under the influence of liquor, we haven't caused an accident yet. It looks like the advocate anticipates that you are going to cause an accident.
Well, frankly, there's so many issues with what the advocate has just said, starting with, of course, the fact that I doubt very much whether many of your viewers actually understand what the various schedules are under the Criminal Procedure Act. That being said, there are 8 of them, and it doesn't necessarily follow that the higher the number of the schedule, the more serious the offence is considered to be. Because, let me give you an example, murder, treason, kidnapping, it's defined under Schedule 1 of the Criminal Procedure Act. Schedule 3 deals only with Section 341 of the Criminal Procedure Act, which enables a traffic officer or a traffic law enforcement authority to issue you something called a compounding notice, which is a notice of intention to institute prosecution if you do not pay an admission of guilt fine. Now, when we start talking about arresting people and denying them bail, and I think that this is the nub that we need to actually be talking about here.
You're saying that because it will be very difficult to get bail if you are charged under Schedule 5 or 6.
You will not get police bail. Schedule 5 and Schedule 6, they prohibit police from issuing bail to an accused person. What is required is that person then must appear before a judicial officer and give reasons. Now, under Schedule 5, that person needs to give reasons why it would be in the interests of justice for them to be released on bail. Schedule 6, they have to go further, and they have to give compelling reasons as to why it would be in the interests of justice. And that's reserved for the most serious crimes. Now, the fact is that, yes, driving under the influence of alcohol or drugs, by the way, because we keep on talking about drunken driving, there is no such charge in the National Road Traffic Act. And incidentally, I would like the advocate's comment on this. Section 89 of the National Road Traffic Act deals with specifically offences and penalties, but yet it omits driving under the influence of intoxicating liquor or drugs having a narcotic effect, which is where I would suggest that the Minister of Transport, the RTMC, and everybody else concerned should start actually looking at their own housekeeping and fixing up the National Road Traffic Act, instead of coming along and tampering with everybody else's legislation, proposing that people be jailed for terms indeterminate until such time as they prove themselves innocent in a court of law. That is what the advocate is actually advocating here. And this is really, really, really dangerous speak, especially in a constitutional democracy.
Let me come back, Advocate. I know you wanted to respond, but Section 35 of the Constitution, subsection 3N, says, to the benefit of the least severe of the prescribed punishment, if the prescribed punishment for the offence has been changed between the time of the offence, that the offence was committed, and the time of sentencing and appeal or review by a higher court, that person has all these constitutional rights. When does the change happen from Schedule 3 to Schedule 5?
Let me deal with the fundamental issue that is raised by Harold. It's a misnomer of this issue. What we're saying in the rescheduling, it's not the rescheduling of the traffic law enforcement. We're talking of the Criminal Procedure Act. We say, what is the Criminal Procedure Act classifying? Drunken driving?
It doesn't classify.
That's the issue. Then we say it's an omission. Let's get it into the Criminal Procedure Act.
Fair enough.
The issue of the...
And what about persons who are subsequently acquitted? Are you here on TV saying that you are going to pay
let's get the advocate to finish what you were saying.
No. This is a state where there is law and order. We're saying as a departure point, let's identify offenses that are very serious in nature. And no one is not, I haven't said anybody saying that drunken driving or reckless and negligent driving is not serious in this country. I mean, this issue must be understood into the context. We're losing, just over the period of 5 weeks, we lost 1,714 lives.
Were they all because of drunken driving?
Reckless and drunken driving.
Or reckless and drunken driving.
Well, that's the issue that
those were the only two causes?
Yes, we're saying those two, we're then putting them at the higher level because already some of those causal nexus and causal links, like fraud and corruption in getting into a driver's license, has already been classified. So we're saying let's take these, which are a major issue in the country. And we're saying human behavior contributes 67% of our road fatalities. So what should then government do? Should we fold our hands and say we want to profile the rights of the individuals? We're saying we need to deal with consequence management. And therefore, the reclassification of an offense doesn't say that a person is guilty or has been arrested.
Well, gentlemen, we'll continue this discussion. It seems it's going to be a riveting discussion. If you'd like to join us in today's discussion, please, you can tweet us at Rights Recourse or email your thoughts to rightsandrecourse@sabc.co.za. Stay with us.
Did you know that hippopotamus are susceptible to sunburn and spend most of their sunny days with only their noses out of the water whilst the rest of their body is immersed in water? Their noses have special flaps that close when submerged and can stay underwater for 25 minutes. The hippopotamus is the third largest living land mammal after the elephant and the white rhino. The hippo is 13 feet long and up to 5 feet tall, and the female weighs up to 655 kilograms. The hippopotamus is a grazer, eats up to 40 kilograms of grass at night, and it has a life expectancy of only 50 years.
ANC moved to ease tensions created by the heated public spat between National Treasury and Eskom.
Eskom denied allegations of impropriety regarding the matter. National Treasury issued a statement accusing Eskom of lying.
The fracas over hairstyles at a Pretoria school has drawn sharp focus on underlying racism and alleged abuse in some schools.
We want relevant answers from the MEC. You must fire the principal.
Here too, similar sentiments of underlying racism.
It just made me feel like I was not worthy enough of an education because of the type of hairstyle that I had. Because yesterday the statement was, writing an exam is a privilege.
Welcome back to Rights and Recourses to discuss the issue of changing those who have been arrested for drunken driving from a Schedule 3 offence to a Schedule 5 or 6 offence. Let's go back to, I don't know, Howard, you wanted to say something. And let's stop you in your tracks.
Unfortunately, I find it very difficult to grasp this concept that the National Road Traffic Act omits under its offences and penalties a specific sentencing guideline with respect to driving under the influence of intoxicating liquor or a drug having a narcotic effect. And I ask the question again, surely the Department of Transport and the RTMC should be looking at getting its own house in order before it starts tampering elsewhere. However, there was something that you brought up, which was Section 35
Section 35 3 is up, yes.
Okay. The fact is that we're not talking about sentencing here. What we're talking about is the arrest of the person and everything that goes prior to the conclusion of their trial. And what is being proposed is that people are detained in police custody until such time as, I believe the spokesperson for the RTMC said the other day on radio, and I'll pull up the recording if you wish, until such time as their trial has been concluded. Do you know that on first appearance, magistrates generally postpone matters for driving under the influence of alcohol for a minimum period of 9 months in order to await blood results to come back? When police release people on bail, they give those people a court date 6 months in the future. Why? Because the problem does not lie in our sentencing, and the problem does not lie in anything other than the fact that our traffic law enforcement authorities fail to convict persons for driving under the influence of alcohol. And let's face it, it's all very well that we want to come along and hammer individuals like Humphreys, like Shabalala, like Morohanya. Okay, we want to hammer those people. Why? Because they killed children. Why don't we get hold of those people and convict them and then punish them in the appropriate manner before they kill somebody? I'll tell you why. Because it's easier to take shortcuts, detain them in police cells, and punish them ahead of even seeing the inside of a courtroom. That is problematic, and I really do urge the Minister and my learned colleague here to actually sit down and have a good think about what they're talking about here.
So, maybe just put in this question, Advocate. Advocate, one of the things is there's an omission in the Act. I think it's the National Road Safety Act?
No. Traffic Act.
The Traffic Act. There's an omission, this issue of drunken driving. Isn't that a legislative issue? Shouldn't we be referring this to Parliament rather than discussing it with just the Justice Department?
No. Let's correct the issue. There's no omission in the Act. And my colleague will know. In terms of the drunken driving, we open what you call the case docket. We don't give you a Section 56.
That's procedural.
Yes.
It's got nothing to do with legislation, sir.
We take the point. We then say, we want to reclassify Schedule 3 to Schedule 5. That will be an issue of legislation amendment. We want to amend the legislation.
So, in other words, what you want amended,
Let's, Howard, let's just give the advocate a chance to finish what you're saying.
What does Schedule 3 deal with?
Let's just...
Now, the issue that we enjoy so much when people are jumping up and down, why are people not jumping when kidnapping is within Schedule 5? Why people are not jumping when murder with aggravating circumstances in Schedule 6?
With aggravating circumstances.
Now, this we then coming into this matter. What we have seen on South African roads, the killing of innocent road users, is it not that serious to warrant that we reschedule the scheduling so that those people that are found on the wrong side of the law can pay the consequences?
If they are convicted.
Now, that's the point. I'm arrested for robbery with aggravating circumstances. I'm not, or murder with aggravating circumstances. I'm arrested. When arrested, I'm given to appear before court. Before court, Section 59 doesn't apply. It's only Section 60. I make a formal bail application. And that's what we are saying. Let people make formal bail application in terms of Section 60. And it is the discretion of the magistrate to then say, do I give you bail or I don't give you bail? But what is important, the onus changes. The onus, it's on you on why we should then give you bail. Can you imagine how many people are sitting with their parents, breadwinners, and orphans that we have? RAF, as one of the entities, is paying about 2 billion a month.
I think, Advocate, where I understand Howard to be saying, that is not where the problem is. And I've read all of these documents for one of the biggest things that comes over and over again is enforcement.
No. We have so much, we've done much of road safety education, we've done enforcement. We are first to say, within enforcement there is also corruption, fraud and corruption that we are dealing with. But enforcement alone cannot deal with this matter. That's why even the strategy combines the two, education, law enforcement, but you can have all this until you deal with the attitude and the perception of the road users. You will not get to the desired rules. So give us a chance, as we are then saying, is it wrong when somebody appears, here is a person, let me make another scenario that has not been even articulated. We arrest a person driving in a Kumbi that takes 15 passengers, 33 passengers. He has no driver's license, he has no PDF. He gets and kills people. What should we be saying? No, it's fine, let this person...
How many people did he kill?
Those that we're sitting with the 16 people that have been killed.
You're referring to which crash?
I'm referring to the
taxi that came from Zimbabwe.
That
didn't crash.
No. The one with the 33 people didn't crash. But I'm joining it with what we had in Hammersclaw.
We can't do that, Advocate. Things are not interchangeable.
No. Let's get into Howard.
Let's be fair about
Here is a taxi in Hammersclaw. 16 people die out of that taxi. You are saying...
No. In that particular instance,
what are you then saying?
You're now referring to a bakkie that veered across a freeway, the center median of a freeway, turned in the opposite direction and came to a halt, and the minibus taxi drove into the back of it. That's what you're talking about. Are you telling me that the driver of that minibus taxi was at fault there, and are you telling me that the driver of that minibus taxi did not have a driving license? Because that's what you're saying.
No. I'm saying two scenarios. A scenario,
you're mixing scenarios.
Let's get
you have a person
to finish.
Getting into a public transport, a taxi,
yes,
33 passengers,
yes,
that person, and the car takes only 15,
yes,
doesn't have a driver's license, doesn't even have the PDF. We pull that person because he's driving recklessly. You saying to us, leave this person, give him a Section 59 notice, let him continue.
Section 59
let's get a response. Let's get a proper response from get a proper response from Howard. Howard, give us a proper response.
Absolutely. Right. There is certainly a deficiency within Schedule 3 of the Criminal Procedure Act with respect to driving without possessing a driving license. That should be a criminal offence for which a person should be arrested, but yet the Criminal Procedure Act allows for a fine to be given. A Section 341 notice, not Section 56. However, We can go into this and we can debate it until the cows come home. Ultimately, what the advocate is trying to do is inject all different matters into different matters here. We must deal with each matter on its own merits. And the fact is that just as much as you can talk about we're arresting people because they are drunk, let's talk about Greg Esterhazen, who was arrested on Christmas Day in 2014 on video on the basis that he didn't want to pay a bribe to go through a roadblock.
We'll come to that. We'll come to that.
We'll come to acquitted.
No, we'll come to that. We'll come to that, Howard. Advocate, let's go to a break. When we come back, we'll continue this discussion. I want to raise two issues which are case laws in this case, which are going to be talked about. If you'd like to join us, you can tweet us at Rights and Recourse. You can email your thoughts to rightsandrecourse@sabc.co.za. Stay with us.
I don't know if I'm going to succeed, but I want you to tell us, who are these three people that you have opened corruption charges against at the Brooklyn police station? How senior are they?
Very.
Are these people who were serving in the political office of the executive mayor?
Yes.
Which means they are no longer working for the city now.
Well, I can tell you that one of them is actually finding themselves employed in another municipality.
You are not going to tell us the names?
No, you're not going to get names for me.
Are people still getting free Wi-Fi in Tshwane?
People are still getting free Wi-Fi, and we will actually make it one of the basic services that our residents will get.
ANC moved to ease tensions created by the heated public spat between National Treasury and Eskom.
Eskom denied allegations of impropriety regarding the matter. National Treasury issued a statement accusing Eskom of lying.
The fracas over hairstyles at a Pretoria school has drawn sharp focus on underlying racism and alleged abuse in some schools.
We want relevant answers from the MEC. You must fire the principal.
Here too, similar sentiments of underlying racism.
It just made me feel like I was not worthy enough of an education because of the type of hairstyle that I had. Because yesterday the statement was, writing an exam is a privilege.
Welcome back to Rights and Recourse as we continue our discussion on the proposal by the Department of Transport and RTMC to charge those who have been arrested with drunken driving under Schedule 6 or 5 rather than 3. The question, advocate, is Section 65 of the National Road Traffic Act of 1996 prohibits driving while under the influence of liquor, drugs, having narcotics effect, and even excessive amount of alcohol in your blood or breath. The question is, do we test all people who are involved in an accident, all the drivers who are involved in accidents?
Well, we do.
But you cannot test them without their knowledge.
No. Anybody who's in now what we're doing, even when a person has passed on, we also then ensure that we take the test to find the cause whether this person was drunk or not. But I know we are raising the issue of the constitutional issue that I must then consent to the people taking a blood. But here's the issue: you passed on. We want to get the issue. Which rights override the other right? So that's one of the issues. But let me get to the issues that we're battling with here and Howard. And I don't hear Howard and everybody says we shouldn't reclassify. I don't hear anybody saying that. But even on that...
No, I'm saying you shouldn't reclassify it.
If you say that we shouldn't reclassify, let me take issue with you. Housebreaking. If I'm charged by housebreaking, it doesn't say it's housebreaking with the intention to commit theft and theft, okay? Even if I've just broken into a house, not having taken anything, I'm charged of housebreaking. What's wrong when we classify drunken driving and reckless, even when you have not killed a person?
I think courts will have a difficult problem in, for instance, we've got two case laws. We've got the Jacob Humphreys case law and the Jub Maruhanya and Chabalala case law, where they were sentenced to 27 years and 20 years respectively. But the judges, the Supreme Court of Appeal, brought those down. In the Jeffries case, in the Humphreys case, they brought it down to 8 years.
But then, the legal fraternity, it's one of the issues that is very interesting.
It's very exciting.
Now we have the judgment of Judge Masupa. Dealing with what? Dolly's eventualities. What had happened in terms of the highest court of the land. So those have come after.
But what is turned around by the Supreme Court of Appeal?
No. Leave the Supreme Court of Appeal. We talk with the judgment that has gone all the way through.
Yes.
Now we now have a new judgment which then deals with precedents in terms of Dolly's eventualities. In the Humphreys, we must distinguish these issues as well as Jub Maruhanya. They were never dealt with Dolly's eventualities. And let's go back to Dolly's.
That's exactly what they were convicted of.
When the charges was overturned. They never interpreted in the correct way as it has now been interpreted.
Okay. The correct way is your way. Is that correct? I understand.
No.
Be reasonable, see it my way.
No. Let's get back from State versus Blom when we're dealing with the intention. But let's get also to Dolly's eventualities. The case, the Oscar Pretorius case.
No. Sorry, but a firearm is manufactured to kill people, with all due respect. But a motor vehicle is not manufactured to kill people.
That's a naive interpretation. Let's get to the interpretation.
Who wants to lock up people
let's get
on
to
the
the
basis that they've been arrested and accused by one of your highly trained traffic officers.
Can the vehicle not be defined if it's misused as a firearm? When you get into a vehicle...
With due respect, advocate, my finger can be defined as a dangerous weapon if I poke it in your eye.
I hope you don't want to poke the advocate in the eye.
That does not mean, no I don't, that does not mean, okay, that we should now turn around and say that somebody who pokes somebody in the eye must be charged with premeditated murder or any other form of murder, to be very frank with you, or attempted murder.
But tell us,
let's give the advocate,
tell us how, if I go and consume liquor excessively and get into, and doing so fully knowing that I'm going to be driving, what am I doing?
You are acting incredibly irresponsibly. You are denying the fact. You are acting unlawfully, absolutely, okay? You are denying the fact that alcohol and drugs, by the way, because you don't care about drugs. The only people you've prosecuted for drugs was Chabalala and Moranya. Sorry, with due respect, that's the only people you've bothered with. The rest of them just do it with impunity, all of them. Your WITS students, your TUC students, the whole lot, they drive under the influence of drugs, and your handheld screeners don't pick it up. But the fact is, it is true. The fact is that we are dealing with two totally separate issues here. One is sentencing. On that, we are on exactly the same page. When a person has been convicted by a proper court, throw the book at them. When a person has been arrested and has not yet appeared in a court, with due respect, my learned friend, you may not punish them as you and the minister proposed to do by detaining them. Have you spent a single day in a South African Police Services cell?
Howard in jail. I think you're right. There's a paper I picked up by Jerome Chaskelson that says Section 35, subsection 1F of the Constitution says everyone who is arrested for alleged committing an offence has the right to be released from detention if the interests of justice permit, subject to reasonable conditions.
That's the point. I'm getting there. You see, we're jumping the car. We are not saying, we're not saying, arrest you, we don't give you pay. We're not saying that.
But the bail must be determined by the magistrate.
By the court.
Yes.
Like it's an ordinary cause, as opposed to now, you get arrested, a sergeant in charge of the police station gives you bail in terms of Section 59. We are saying that process is the one that let's reschedule to deny that process so that you go through all other processes, go to a magistrate. And Section 35.
Let's dispose of Section 59 entirely. Let's just
have a problem. No. Section 59, we are not going to dispose of it because there are other charges in relation to theft, minimum theft. We are not concerned with that.
Why not?
We're concerned with the offences that occur on our road infrastructure. But the point that we're getting, get to Section 35. Read Section 35 of the Constitution very clearly, and Judge Arthur Shackleton has put it very clearly. You have a right, but it doesn't end there.
If
the interest
it's in the interest of justice. Correct.
And
how is it in the interest of justice to detain a person once they have sobered up?
You see, I understand what you say, Howard and the advocate. I have a problem with anticipating that a person who's driving under the influence of liquor is going to cause an accident.
No, I'm not anticipating. We're saying, and this is where we differ with you, reclassify the offense. What does it mean? If you're going to be driving under the influence of liquor, you know already.
I think, advocate, I'm not trying to argue a point. I'm just trying to say, if I am arrested driving under the influence of liquor, I should be charged under Schedule 3. But if I do cause an accident, then I can be charged under Schedule 5.
You are not charged under Schedule 3 as it stands now, with due respect. I don't know what charge or what schedule, because it's actually not defined. But I would argue that it should be Schedule 1, Schedule 2. You can even go to Schedule 7 and tamper with the culpable homicide charge which exists in that and Schedule 1 and say, if there are aggravating circumstances to a culpable homicide, i.e. that a person has been arrested whilst under the influence of alcohol, that person must appear before a magistrate. But may I ask you a very simple question? Do you really think that it takes the level of a magistrate to determine whether a person is sober, the person standing before him is sober or not? Because you know what? SABC, Standard Operating Procedures, and you should know this, dictate that person must be detained for a minimum period of 4 hours. And in reality, those periods extend into 12 and even 18, 24 hours by the time that person gets released. Surely by that time that person is sufficiently sober to be released on bail. Remember, bail is not a fine. Bail is not a, well, just go do as you please. It's a guarantee that you are going to appear in court to be tried for the charge for which you have been charged. And ultimately, I think that we need to get our thinking straight. I know that the new flavor of the month is driving under the influence of alcohol, and on that score, you've actually said that 65% of those people, those 9,500 people that you arrested during the festive season, were under the influence of alcohol. I would like to challenge you here, live on TV. This time next year, when we have this discussion, come back and tell us how many of those people you've convicted. Just a percentage, that's all we need.
I want just to move away from this. So I think all of these things, reckless driving, driving without licenses, driving under the influence of liquor or otherwise, all points to one thing. The minister pointed out that there's endemic corruption in the licensing and roadworthy testing stations. How do we hope to root all of this out when we have this?
No, Dumile, that's what I said, that let's separate the issues. We are not, we're not talking of the wholesale industry. We're very clear. We're saying traffic offenses, which are 1, reckless and negligent driving under the influence, should be reclassified. We are not saying everything. And we have the reason.
I just pointed to the fact that all of these stem from the endemic corruption.
The corruption, it's a different issue. It's already in our statute book. It's already in the criminal procedure. And by the way, we arrest people, and some of our own, the traffic officers, for fraud and corruption. We do. But what we have not done, which the minister has spoken about, and which we are now saying to the police, it takes 2 to tango. We now need also to arrest the person who is corrupting our traffic officer or who's been corrupted by the traffic officers, and watch the space to me. The next time I come here, we'll not have only arrested the traffic officers, but also the people that have been corrupting. Let me just then say on this, because Minister fell short of saying it. We have long been doing this, and everybody has been saying we're talking one and the same thing over years. But you'll know, in order to make your case to stand in court, you will invest more time to investigate. Since 2014, we have been investigating people who obtain driver's licenses. And you'll be shocked that we're now taking statements from those that have bought licenses, so that two things are going to happen. One, we're going to arrest and charge them for fraud and corruption, but also going to cancel the licenses. So now it shows how serious we are, because people are saying we have been talking. But investigations, because when people are charged, they have the right to the lawyers, and they pay the best lawyers. So what you do as the state, you ensure that you invest more time to investigate and close all the loopholes. And we wait for that day. And I will invite my colleague to come public and say, we were misleading the public all along, saying that the state is not
starting that.
Gentlemen.
Let's talk about misleading. Let's talk about misleading.
Gentlemen, we need to go to a break.
Right now, how many officers do you have in your anti-corruption
Howard, we need to go to a break. When we come back, if you'd like to join us, you can tweet us at Rise Recourse. The fight is still continuing here next to me. Gentlemen, I'm sorry, we need to go to a break. Please stay with us, and we'll be back right after this.
14 million.
AIDS and poverty did not deter Mpumi's success.
Being an orphan or coming from poverty or having seen what HIV and AIDS does to a person that you love takes nothing away from you. It means that you are part of a selective few who have had to face a very, very marginalized struggle.
Abuse is a lonely journey that needs compassion.
I came across as a very confident, ambitious person, but behind that mask was somebody who had serious anxiety problems, a person who had knots in their stomach continuously, a person who could be in company and would feel very lonely.
Being away from his birth country did not stop his hunger to succeed.
Boxing was the way out. Turning professional would give me an income. That was the solution to the problems I've had for so many years.
For more inspiring stories, join Dipuo every Friday at 17:30.
Water-wise, water is an essential need. The scarcity of it could lead to loss of many lives, including livestock, plants, and much more. It requires us to use it sparingly and responsibly in times of need, failing which our taps and sanitation will not function. For more on water and weather issues, stay tuned to News Today, every Friday at 4:45 Central African Time. SABC News, making you water-wise.
Interesting.
Welcome back to Rights and Recourse. And somebody said to me, advocate, somebody said to me, why does the RTMC and the Department of Transport not just say once and for all, everybody must be retested?
Well, I've said that we're a democratic state and there's legislation. You just don't wake up tomorrow and revoke. The license, it's not a right, we know, but it's a privilege that you have been given. So the law requires us to give cause, show cause why it should be done, or show cause as the person who's the holder of the license, why it should not be revoked. And that's the process that we have investigated, so that when that process comes, we're not just going to take you to court, we'll issue it summons. First, there are two issues. There's a criminal process and there's a civil matter where we're going to ask for a declaratory order to cancel all those. But we're going to cite all those people that are involved to show cause why their licenses should not be revoked. That's one aspect. That's the civil matter.
You know, to answer your question, the National Department of Transport, and you may not be aware of this, did publish a proposal to retest every person who goes to renew their driving license. The problem with that particular draft legislation was they left it to a subjective decision of the examiner as to how he wanted that test, he or she wanted that test to actually pan out. Now, the fact is that we were the ones who suggested that this is the only way to detect whether people have acquired their driving licenses legitimately or not. But there are logistical issues like you cannot believe that go with this. Insofar as when you go to renew your driving license these days, you have to have your fingerprints taken, you have to have an eye test. That's time consuming enough. To now undergo a test on top of that would be a problem. But increase the capacity. Very, very simple. If we really do care about how many people are dying on our roads, and we really do care about the 143.9 billion rand that was lost by the economy, by fatal crashes on our roads, or not only fatal crashes, but all crashes on our roads, then surely we can invest that money to make sure that everybody is competent to drive on our roads. And let's just take that a little bit further, and I know that the Department of Transport and the RTMC are in discussions with respect to the K53 and all that. But the fact is that we need to ensure that everybody is aware of something called hazards on the road. People do not appear to have any sense of what a hazard represents, nor do they have any idea how to avoid those hazards and how they should be planning to avoid those hazards. If we can get that right, we'll be going a long way to solving this problem. But ultimately, one of the most important things here, and I think we are all on the same page on this, even myself and my adversary here, okay? Traffic law enforcement has to be practiced consistently, ethically, corruption-free, 24/7, 365 on our roads. Plain and simple.
One of the things, Advocate, that for me, we spoke earlier about taking people to court, and one of the biggest, there are huge delays for blood testings at blood testing centers. How are we going to stem this reckless driving thing?
That's the issue of the past. The Department of Health, we have now been up the process. The maximum time that you can have in terms of the blood test is now a month.
1 month?
Yes, that's the maximum. So Department of Health have got into this, they've speeded the process in terms of the laboratory services in dealing with the blood, but also as RTMC we are now partnering with certain institutions where blood will be automatically within 7 days or so. We'll be doing. It's a huge investment that we're doing.
You can partner with private laboratories that'll give it to you within 24 hours.
24 hours.
But the cost
there's something else I wanted to ask coming here is, the other problem is in Section 40 of the Criminal Procedure Act, police and traffic officials may arrest without a warrant any person who is driving a motor vehicle under the influence of liquor. But under the National Road Traffic Act, even though police officers have duties of traffic officers, but the traffic officers do not have the duties of the police officers.
Well, it's a very clear issue that you have two distinct issues, but you will also know that it is in the Constitution as well as the resolution of the ruling party that you need to ensure that you have the single command of the law enforcement. To that extent, we're working at the integration and harmonization of the law enforcers. It's one issue. But you also, in the similar vein, you have Section 64L of the Police Act, where the police commissioner will then extend certain powers to the traffic officers, as you have in the metros, that they have Section 64L that they've been given to deal with the issues that ordinarily will reside with the police.
The other thing, Howard, when I was growing up, the most feared traffic officer was a provincial traffic officer. Today, I don't think anybody fears provincial traffic officers anymore.
I don't think anybody fears traffic officers, period, to be very honest with you, because they've earned themselves a shocking reputation. There's not just one or two cases of corruption that have been seen. There's not just one or two cases of outright abuse that have been seen. There's a lot of it. And unfortunately, a lot of the incidents that actually occur out on our roads arises out of lack of respect going both ways, to be very honest with you. People have lost respect for law enforcement officers and vice versa. Law enforcement officers are being taught that they're some kind of special breed and everybody's going to respect them because they wear a badge and a gun. Got news for you, it doesn't work like that. But the fact is that we all interact with one another on a basis of how the other person interacts with us. And if you're going to pull over as a motorist and turn around and say, "Futsak Wena, you're just a corrupt traffic cop, speak cop, get out of my face," that's not going to endear that traffic cop, you in that traffic cop's eyes. But similarly, when traffic officers shoot people in central Pretoria because they allege that they were bumped by that person.
I think that case is before the court, so let's leave that case for now. Let's come to something else.
But I need to correct this because it will be wrong of me to sit in here and not correct the situation. Not all traffic officers or law enforcers are corrupt.
They're not.
We need to acknowledge that we do have certain elements within the law enforcement fraternity. But there are good guys, men and women out there. We are arresting left and right the members of the public that are trying to bribe our members. And there's another issue that we should deal with the perception in the South African minds. Law enforcers are viewed by the conduct of the taxi operators. And it is not correct that everybody should be viewed within that context. And the public, when we really impound these vehicles and the drivers taking them, they're the first to jump. I'm late at work, I'm going to lose my work, and these guys work under very strenuous conditions where they're abused, insulted. We just had an operation out on...
Advocate, just for the last minute, for the last few minutes we have, I want to come to something that is very important. That is the ARTO Act. What is happening in that space?
You've got the wrong CEO here, I'm afraid.
I've got a wrong CEO. I should have the enforcement CEO.
In fact, on this one, I'm going to give you a gimme.
We should have the RTIA. A good friend of mine.
Whatever you want them.
No, but the legislation is before Parliament.
The legislation is before Parliament.
Yes,
and we've been promised yet again that this year, just like in 2009, 2010, 2011, 12, 13, 14, 15, 16, and now 17, it'll be implemented. You know what? Go tell somebody who's actually likely to believe you, with all due respect.
In other words, those are the guys who would be responsible for the demerit system, the demerit point system.
Yes.
The other question I want to ask you is probably from the accidents that we've had over the last Christmas, how many of them were because of on-roadworthy vehicles?
Well, we have said in terms of the vehicle statistics, 10% of the issues was, we said 10% was of course due to the unroadworthy vehicles. So we can give those figures in detail and as to what really happened, but generally you cannot separate the factors that you have spoken to, reckless and negligent driving, drunken driving, and unroadworthy vehicles. But as I have said, Dumile, in my issues, that I separated and categorized these issues on 3 categories, because it doesn't help that we should then begin to lump all of them. We want to be assessed in terms of the performance, in terms of those categories. Deal with us on the wreck and neck, deal with us on the drunken driving, deal with us on the unroadworthy vehicles. Those issues, it's unfortunate that the 3 of them have underlying factors like fraud and corruption in them.
Howard, last word from you.
Frankly, it is much of the same rhetoric, with due respect. And I would really, really hope that one of these days the finger pointing would stop and our authorities would understand that they actually need to take a little bit of the responsibility for the situation that's arisen. It's arisen out of their inaction. Calling an audit of driving licenses now, or driving licenses now, 15 years after the Special Investigation Unit made you aware of the fact that this corruption was so rife, does that not show you the sense of urgency that we have? And I really do hope that this time next year, the advocate and myself will sit here and he'll tell us how many of that 65% of 9,500 people were convicted for driving under the influence of alcohol.
Gentlemen, I must thank you very much. This has been a riveting discussion. The first time I had people going at each other, and I like that. Not that I don't like it. Well, this has been Rights and Recourse. The views expressed on this show don't necessarily reflect those of the SABC or Rights and Recourse. This program will be repeated at 5 on Wednesday morning. You can also find us on YouTube. From me and the rest of the crew, goodbye.